afternoon, all FPI members. Time for an update from the FPI. So what happened in our universe last week? The first thing was that there's some news from the BHI Trust. Now, the liquidators of the trust, or the trustees that are now looking after the money that is left and what isn't there, has found that there are claims of more than 1.6 billion against the trust, and over 800 creditors have come forward saying that the collapsed investment trust owes them money. Now, this is hundreds of millions of rands more than the figure of 1.18 billion mentioned in court when Craig Warrener, who handed himself over to police last year, appeared in the dock in November. So it was the amount that was invested was completely underestimated or misdirected. So there is still little clarity about what happened to the funds that flowed through that trust in the decade between 2013 and 2023. And the investment scheme's court-appointed trustees are now seeking to unravel this mystery. And they are also looking to claw back around 300 million from investors who got payouts after April, not October, after April last year. This is not going to be an easy task. And they have also admitted that it's highly likely that at least some of those demands for payment will be challenged in court. So let's see what happens there. A lot of money involved, and it is a bit of a clad on the investment industry and also on financial advisors that were involved with that. Then in a second update is on the new Ombud, is that the first Ombud was appointed, or the first head Ombud was appointed. Reana Steyn, the first head Ombud of the National Financial Ombud, says the newly formed scheme will make it easier for both consumers and the industry to deal with complaints in the financial service sector. Now, this National Financial Ombud started operating on the 1st of March, is actually an amalgamation of 4 former bodies. It's the Ombudsman for Banking Services, Credit Ombud, Long-Term Insurance Ombud, and Short-Term Insurance Ombud. So it'll make it a little bit easier for consumers if they have got complaints to know where to go and not have to go through all types of hoops and trying to figure out who the correct Ombud for their claims is. So Reana Steyn was the lead Banking Services Ombud from July 2017, and she has held various positions during a roughly 3 decades in the financial services and legal industries, including at KPMG. She was at the National Credit Regulator. She also holds BCom Law LLB and is an admitted attorney of the High Court. So let's see, they will be doing good work at the National Financial Ombud. And then in the last case, there was a case study that you might find very interesting. So as everybody knows, when you pass away, Section 37C of the Pension Funds Act qualifies your spouse as an automatic dependent on your pension fund, and that person can put a claim in against the payout from your pension fund. However, in a case before the pension fund's adjudicator, they confirmed that even if you qualify as someone's legal dependent, in this case the spouse, it does not automatically give you the right to receive a portion of that person's death benefit. Now, the facts are as follows. This woman, the claimant, was the life partner of a businessman for 17 years, and she laid a claim to a share of his death benefit, which totaled 21.3 million. The pension fund trustees, however, allocated the entire pension fund payment to his 2 daughters, on the fact that while they were cohabitating, she and the now deceased actually signed an agreement years before in which a waiver stated that she could not claim a share of his pension, deceased's funds, investment funds, profit sharing, or other retirement interests. So the pension fund trustees then followed that instruction. They allocated to the 2 daughters 50% each. The complainant then came back and said the fund did not acknowledge her as a dependent, and she asserted that his 2 daughters were fully independent and employed businesswomen who also received significant significant inheritances and business interests from the deceased. However, the complainant was not left destitute. She did receive 7 million from various policies payable to her as a result of the deceased death. And although they could prove that she did sign the cohabitation agreement, she also claimed that she did not understand what was included in the cohabitation agreement, and that she would be signing a waiver of the pension fund of the deceased. However, the pension fund's adjudicator did confirm that the fund was correct in identifying the deceased's 2 biological daughters as the beneficiaries. Although a permanent life partner indeed does qualify as a dependent, that does not mean such a person is automatically entitled to a portion of a deceased life partner's death benefit. And the Provident Fund Board correctly allocated the death benefit, and there was no reason to set aside the board's decision. She dismissed the complaint. So go and see if you can find it on the Pension Fund Adjudicator's website, also on the FSCA's website. Both places this was published. Very interesting court case, and something to think about when you're doing financial planning for your clients. Thank you very much and have a wonderful week.